Hello and welcome back. We're nearly at the end of this massive companies finance chapter and also pretty much at the end of the companies section of the notes. So if you're finding it a little bit dull, don't worry, the end is in sight. Now we're going to look in this lecture at how a company might raise finance by issuing debentures. Now what we really mean there is we mean that it's going to borrow money. Now a debenture, posh definition, a written acknowledgement of a debt, or sometimes called a loan note. Okay, now it's usually a written document, it's normally a formal legal document, and a debenture is the loan itself. A loan could be secured or could be unsecured on the company's assets. Now if a loan is secured, then we usually secure it by giving a charge over assets. And if you just think about that in respect of your own mortgage, your own house, then you have given the bank security over your house for your loan, and that security is by way of a legal charge. Okay, now debentures can be issued just like shares really. If you're a PLC, you can issue them to the public, you can quote them on a stock exchange, and you can transfer them in the same way as shares using a stock transfer form. Now, why would you go for debentures? Why would you go for shares? Well, it's an interesting point, isn't it? Because from the investor's point of view, a debenture is a little bit more secure because you can take security for your capital, and also your interest must be paid regardless of whether or not the company makes a profit, i.e. you're not waiting for distributable reserves. So that can be quite good. You've also got a fixed return. The downside to that, of course, is that if the company does incredibly well, if you were a shareholder investing in a company, you might participate in the upside. But as a debenture holder, you have that fixed return. There is no upside. From the company's point of view, why might they want debentures? Well, the main reason, a debenture holder does not own the company. So debentures holder, if you issue debentures rather than shares, you do not give up management rights, which might be quite important. But the downside to that is that you must pay your interest regardless of whether or not you've made a profit. Therefore, it means that you might find that that interest payment is a big expense, almost a noose around the company's neck. So you have to be a little bit careful here. Debentures generally are a bit more flexible as well than shares because they're not share capital, therefore they're not subject to the capital maintenance rules. Now, this table here is quite an important little summary there of the difference between ordinary or equity shares, preference shares and debenture holders, and it's a good one to learn. Very easy for the examiner to test these points. And you'll see that ordinary shareholders, they own the company, they have voting rights. Because the capital maintenance rules apply, then they can't be issued at a discount to their nominal value. There are statutory restrictions on redeeming the shares, and of course the ordinary shareholders, they're right at the bottom of the pile when it comes to repaying capital when a company is wound up. Preference shareholders, they're slightly better position, but they still own the company. So again, if we link these together, preference shareholders, very like ordinary shareholders, they own the company. And although they do get voting rights under the Companies Act, that's usually excluded, so they don't normally get a say in the management. Because it's share capital, it can't be issued at a discount, the return is a dividend, and you're subject to the statutory restrictions. In terms of redeeming shares on liquidation, the preference shareholders usually get paid before the ordinary shareholders when the company's wound up, but that does depend on what the articles say. In terms of a debenture then, what's different? Well, you don't own the company, you're a creditor of the company. As such, you get no votes in the management of a company. Because it's not share capital, you're not subject to any of the capital maintenance rules on redemption or issuing at a discount, so you can do all that. And the repayment, the return on your investment as a debenture holder is interest on your loan. Now, priority of payment is difficult for a debenture holder. It depends whether you're secured. If you're a secured creditor, you're right at the top of the pile to the extent of your security. But if you're unsecured, you're still going to come in before the shareholders, even if you're just an ordinary creditor. And that's something we'll look at in a little bit more detail in Chapter 8. So, if you give security for your loan, how do you do that? Well, we do it by giving a charge over our asset. And as I already said, a mortgage is probably the example of a legal charge that you're most familiar with. Now, there are two sorts of charges that the company can give. The first one is a fixed charge, like your mortgage. Now, the key point here is that if you give a charge over an asset, then that asset cannot be sold unless the charge holder agrees to it. So if you want to move house, for instance, you'll have to get the bank involved in that process. And usually we give a fixed charge over assets such as land and buildings, things that we use in our business but we're not likely to be selling on a regular basis. Therefore, if you're a company that perhaps operates from a rented office, doesn't have a lot of long-term assets, how are you going to borrow money? Well, you might give a floating charge. And the floating charge attaches to a class of assets. So we're looking here at something like maybe book debts or work in progress, stock, your warehouse, things like that. Now, if that was a fixed charge, that would probably grind your business to a halt, because every time you got an order for goods or you wanted to pay a debt or pay an invoice, you'd have to get the bank's permission. But if it's a floating charge, the floating charge kind of floats over that class of asset, but doesn't actually attach. And because it hasn't attached to the asset, then the company can carry on dealing with those assets without the charge holder's consent. And when that charge crystallizes, which means it attaches to those assets, then at that point it becomes a fixed charge. And at that point, the company would need the consent of the charge holder to deal with the assets. Now, what crystallizes a floating charge depends on the terms of that floating charge. But usually it's things like not paying the interest on time, maybe the company becoming insolvent, maybe an administrator being appointed, things like that, which would then crystallize the charge, cause it to fix. And the key test that the courts usually use to decide whether something is a fixed charge or a floating charge is to say, can the company deal with the asset without the consent of a charge holder? Now, it's worth mentioning here as well, companies can grant floating charges, but sole traders and partners can't. So let's have a look at these in a little bit more detail. First of all, security. Well, you can take security for either a fixed or a floating charge, that's the point of a charge, but with a fixed charge, it's attached to an identifiable asset at the outset. And as we said earlier, the debtor can't deal with the asset unless he has consent. A floating charge doesn't attach to any asset until it crystallises, and therefore the company can carry on dealing with that asset. Priority of payment is interesting. Fixed charges always get paid first to the extent of the security. So the fixed charge holder can take the asset and sell it, use the proceeds to pay their debt. A floating charge holder, you might think, is similarly protected, but just over the class of assets they've taken as security. However, you'll be surprised to know there's a few people who can sneak in ahead of the floating charge holder. A judgment creditor, if he gets there first, basically, if he takes the goods before the charge holder's receiver gets there. Preferential debts, remember this is basically employees' salaries. They are paid before the floating charge holder. Fixed charges we'll look at in a second, so we'll ignore that for now. Also, we have something called a remolque clause, mentioned down here, see. Now, this is where you supply goods to a customer, but what you do is you include a condition in your sale agreement that says you keep legal ownership of those goods until you've been paid in full. And that means that although those goods might be sitting in the company's storeroom, they're not there for the charge holder to take because they don't belong to the company. They still belong to the supplier. And then finally, a relatively new provision is something to do with the Enterprise Act, which we're going to look at in a little bit more detail. Now, the Enterprise Act was introduced, and one of the things it was trying to do was to protect smaller businesses. Because what often happens when a company fails is that the money goes to the top few categories of creditors. It goes to those people who've got fixed charges, those people who've got floating charges, and they tend to be the big banks. And your poor old supplier doesn't get paid. So the Insolvency Act said that we'll ring fence a proportion of the company's assets and we'll use those to pay to the unsecured creditors. So even if everything is subject to charges, there'll still be a little bit that we can scrape out and pay to the ordinary creditors. And we'll see more on that in Chapter 8. If you want to enforce your charge, if you're a fixed charge holder, then you will appoint a receiver who can seize that asset for you, can realise the asset and then pay you the proceeds. If you're a floating charge holder, you appoint an administrator or a liquidator, because in a way, with a fixed charge, you've got a charge over a specific asset. But with a floating charge, it's usually over sort of the main assets of the company, the stuff that it actually carries out its business with. It's worth mentioning also the security of your charge. So a fixed charge is usually pretty secure. The only time it can be undone is if you gave it within 6 months before the company became insolvent. And we'll look at that again in Chapter 8. But a floating charge, the period goes back a bit further. It's 12 months. So if you grant a floating charge to your creditors and become insolvent within 12 months, then that charge might well be set aside. So again, the floating charge holder isn't nearly as safe as he might like to think he is. Now, there is also a problem, because let's imagine we have a business that grants 2 charges. Grants one of 5,000 and one of 7,000. That means that my business has charges of £12,000, but it only has assets of 10,000 when it becomes insolvent. So what's going to happen? Well, you might think that everybody would get 10/12 of their debt. That would seem fair, but that is not the way it works. The way it works is basically first come, first served. So the first charge will get paid in full, and the next charge will get what's left. So in this case, my first charge of 5,000 will be paid in full, and the second charge holder will only get 5,000 of the 7,000 that's owed to him. Now, we can tweak that a little bit further, because legal charges, by which we mean fixed charges, get paid first. And we pay them, if there's more than one fixed charge over the same assets, we pay them in the order of creation. Okay? Equitable charges, by which we mean really floating charges, they get paid second after the legal charges, but again, according to the order of creation, which means that legal charges always get paid before equitable. That means even if there is an equitable charge created first, the legal charge can still sneak in and get paid first. Which seems a little unfair, doesn't it? And to deal with this, floating charge holders will often give a negative pledge clause. Now, this is a term that they write into their charge agreement, which says that if it says that their charge will always be paid in priority to a subsequent fixed charge, to try and get around that problem I just described. Now, that clause is effective, but only if the fixed charge holder has notice of that clause. If he doesn't know it's there, and he doesn't know that there is an earlier floating charge, then he won't be bound by it. Okay, and that's called a negative pledge clause. Now, once a charge has been granted, there's a couple of things that need to happen. The company must keep records of the charges. You remember those books, statutory books, that are kept at the company's registered office? Directors charged by the minute, register of directors, register of charges, register of minutes. This is the charges register. And it's details of every instrument that creates a charge. No, that's the charge, not the fact that the company has debts, the fact that it has security for its debts, or that it's given security for its debts. And on that you also have to have a register of the charges, and that gives details of all the fixed and all the floating charges, and of course the assets that are subject to those charges. Because if you were going to lend money to the company, you'd want to inspect that register and make sure that you were aware of all the charges that were already granted that might rank in payment terms before yours. And as it says there, those statutory books available for inspection by any creditor or member, free of charge, and anyone else has to pay. There's also another register as well, and this is kept by the company's registrar at Companies House. And basically, whenever a charge is created, it must be registered with the registrar within 21 days. Once it's registered, that sets in place the order of payment that we described in paragraph 3.4 there. But if it's not registered in time, then that charge can no longer be enforced, and it can no longer be enforced against the liquidator, administrator or creditor of the company. So basically, we're talking about on insolvency, which is exactly when you'd like your charge to be secure. So failure to register has fairly dramatic effects for the charge holder. There are also consequences for the directors of the company, because they can be punished by a fine as well. Now, if the security for your debt does become invalid in this way, then what you might do, the debt automatically becomes payable on demand, which means that the bank could actually insist on the money being repaid, and then they could reissue the charge on favourable grounds, so it can be registered in time. There is discretion for late registration, but the registrar will only do that if he's absolutely sure that nobody's interests have been affected by the late registration. What do you do if you have a charge over assets? Well, if you have a charge, you will appoint an administrative receiver to act for you. If you're unsecured, it's a bit more limited. If you're unsecured, you can apply to the court for the company to be wound up, compulsory winding up, or you can appoint an administrator to try to rescue the company and make sure everybody gets paid. And we'll see more of that in the next chapter. Okay, so that is details about debentures and charges. If you're struggling with that, please do ask for help. The key points really are the differences between the debentures and the shares, and also that point about priority of charges, which we've just discussed. Okay, and I'll see you soon for the next chapter.